Identifying your company's intellectual property. So one of the things we see is that a lot of people don't understand, and this includes many other lawyers that don't handle intellectual property, what is what it is that they're seeking to protect, whether it's a patent, a copyright, a trademark, and whether it's something that just can't be protected, such as ideas. So figured I'd run through, we have on our website here a place to ID your IP, and if you just go to jhrlegal.com and go to resources, ID your IP, it'll take you to there. So there's a chart to help you identify, but before we get into it, just to give you a little background as to what are trademarks, patents, and copyrights, and what do they protect. So trademarks protect source identification so that you know where the goods or services are coming from. You know when you see a Nike swoosh on a hat, a clothing, shoes, you know that that's coming from Nike. You know the quality, or at least at one time, what the quality of that product was. Trade dress also falls on that. So you know when you see a McDonald's from far away, just based on the look, the colors of it, that it's a McDonald's. So you know what to expect when you go there if you pull in. So that's trade dress. And trade dress can also protect some other things like the look of a product, the packaging, the coloring scheme. You know it when you see it, certain slogans for Nike, again, just do it. For logos, when you see those, you know who the source of those goods or services are, and that's trademarks, service marks, trade dress. Um, those can be protected indefinitely. So long as you keep using it, you can renew that registration. So copyrights. Copyrights protect the expression of an idea. So trademarks protect where the goods or services are coming from, the identification of that source. Copyrights protect the expression of an idea. And then to just jump quickly into it, patents protect inventions, things that are new, useful, non-obvious, and I have a separate video that really describes those three requirements there. But let's go back to copyright. So copyright protects the artistic expression of an idea, as I said, and that could be anything from literary works, photos, graphic design work, hand drawings, paintings, things like that. And then patents protect inventions. And this is where a lot of people get confused because they think that a patent protects an idea. So patent cannot protect the idea of a car that flies or a car that runs on battery, but what it can protect is actually all the many little inventions that go into it to make a car lift off the ground and move forward, all the thrusters, everything to steer it, all those separate little inventions that would need to be created to create a car that flies. So let's just go into some of the examples here. So, obviously brand name, product name, and business name, that's something that's protected by a trademark. Logos can be protected both by copyright and trademark because a logo is essentially a piece of art. So you can protect the artwork of it, but then you can also protect the source identification that's created by using that logo. And you might file for both to have the broadest potential intellectual property protection because they kind of protect different things. So when you do file a trademark or service mark, it's filed for your services or products in connection with that type of product or service that you are selling or providing. So that's why you can have, Delta is an airline company. I've seen Delta pharmacies, there's a Delta clothing company. Those can all coexist because they're far enough away from each other in terms of what they provide. Now, you might not be able to have a Delta, you know, travel, agency or something like that because that would be too close to Delta, the airlines. There's also Delta faucets. So That's how trademark works. But if you have a piece of art, it doesn't really matter what you put it on. If you're infringing on the artwork, you're infringing on it. Slogans are covered by trademark, service mark. Product packaging, as I said, could be trade dress, which is in this list. I didn't do a separate trade. It should be trademark, service mark, or trade dress. But product packaging would be something that could potentially be under trade dress. Think of the Coca-Cola bottle. That look is protected by trade dress. Copyrights also, depending upon what the packaging is, if it's like a box that has artwork on it, a unique box, that could potentially be protected by copyright. Another example of trade dress is the Tiffany's, that color blue, and UPS, the color brown, because you know when you see the blue, that blue color that Tiffany uses on a box, you know where that came from. Same thing with the brown that's used by UPS for their trucks. When you see a brown truck down the road in that color and shade of brown, you know it's UPS. So two-dimensional designs, that would be kind of like a piece of artwork that definitely could be protected by copyright and potentially by a design patent. So design patents protect new, novel, aesthetic looks of a product of manufacture. So one way it protects in 2D designs is graphical user interfaces on computers, on phones. In fact, that's how Apple won their big lawsuit against Samsung, was the actual screen, which that's not going to show it, but the way the icons were laid out, the way they looked, that was something that was novel when the first iPhone came out, and essentially the courts found that Samsung's was too close to that look. And then there's, three-dimensional shapes, and we're talking more about the appearance here and not the function. Again, that would be something by design patent. So that, I think, also Apple had the design patent for the look of the screen, the shape of the whole phone was something unique. It did not exist before they made it. So that could be protected by design patents. But also there's sculptures and other artworks like that that are three-dimensional pieces of art that could be protected under copyright. Then, of course, I mentioned before, any sort of creative artistic works such as writings, art, video, audio, graphic, website content, blog content can all be protected under copyright. Software source code is essentially considered a literary work. It's text that you write out, so it's protected under copyright, but it also might be something that you want to consider just keeping a secret and maintaining it as a secret. If you think of the Google algorithm, things like that, those are just trade secrets. Software functionality, web apps, business methods, trade secret can apply there in the actual code, how it's working. But if there's something that you're not as much concerned about someone taking your exact code, because that's what the copyright would protect, but you care more about how it functions, then you might want to look into a utility patent for that. Now, there is right now a very high bar in what constitutes an inventive subject matter when it comes to apps and software, but it still is possible. Again, as I said before, how your invention looks, the aesthetics, the ornamental design, graphic user interface, that is covered by design patent and copyright. And then formulas and recipes. These potentially, if it's something completely new, it is, think of a lot of pharmaceuticals out there are protected by patent. There are new formulas that have come up. But a lot of recipes for food, most of the time, you're not taking anything that didn't at some point in the past get mixed together. So most likely that's probably going to be protected by a trade secret. And there again, you can think of the formula for Coca-Cola, KFC's Spice blend. Those are all things that are considered trade secrets, and the only way to keep something to maintain it under a trade secret is to keep it a secret by contracts, by access to only those that actually need it. You know, if it's a formula, keeping it in a safe under lock and key. If it's, software, uh, access to the algorithm or the software can only be done through password protection, things like that. You have to put steps in place. And for trade secret, once the cat's out of the bag, it's out of the bag, meaning if someone learns about it or figures it out on their own, or potentially even if you get hacked and it gets posted online and people learn about it, there's nothing you can really do to stop others from using it at that point. So unless, of course, they were the ones that sought to have someone release it online, maybe you have some other claims against them. So that's just kind of a quick run through of differences between patent, copyright, and trademark and trade secret that we work on here. We primarily do the prosecution of intellectual property. So what does that mean? That means we help our clients, we counsel them and advise them on whether or not they're infringing on someone else's rights, whether or not this would be a strong trademark, a strong patent, that it's worth pursuing. And then if so, what's the best course of action to pursue that? Because some of these, it's not as simple as just filing and then you get the registration. There has to be some thought behind it and how, so that it'll go through the patent and trademark office as smooth as possible, because you want to have as little back and forth as possible, because of course anything you say can and will be used against you at a later date when you go to assert it against someone, or should someone seek to have your rights canceled. But we work with our clients to do that, from counseling them at the very beginning, what's the best steps, also helping them harvest their invention, their trademark, meaning figuring out what is patentable, what is trademarkable, how could they use things in a way that would be of a trademark use. Those are the different type of things that we help them with. We do assess infringement, and on occasion we'll send out or respond to cease and desist letters or demand letters on behalf of our clients. But in general, although we support litigators, if someone gets sued, meaning we'll come in and help them assess the intellectual property aspect of it, the patent, the copyright, the trademark, but we are not litigators. We do not sue people for infringement. And generally, we do not defend against infringement. If it's early enough on, we may help to guide our clients on how to respond, and also point them in the right direction as to which counsel to work with, who would be proper under the circumstances. So it's just a little bit about us, about how we help our clients. And we take a very business-minded approach to it, meaning we don't want you to just do something so that you file for the trademark or the patent. We want there to be a business reason behind it. We want it to be a decision that is made essentially that for the benefit of the company, of your business, to add this intellectual property as an asset to that business. So if you like these, of course, subscribe below. Feel free to reach out with any questions, and thanks for watching.